I'm Jeb Butler, and this is Brittany Partridge. We're lawyers at the Butler Kahn law firm, and wanted to talk today about a single car collision where we represented the passenger and settled the case for $1.7 million. Tell us what happened, Brittany.
Yeah, so we represented the family of the passenger in a single car collision, like Jeb said. Our client was driving with his friend, Ben, and Ben was traveling down a 45-mile-per-hour residential road, but going over 100 miles per hour. At some point on this road, Ben winds up losing control of the vehicle after striking a mailbox, overcorrects, and winds up in a field. And we actually have a photo from the scene that we took, and I'm going to try my best to illustrate here kind of what happened. So Ben is traveling down this road here. He strikes a mailbox right about here. He overcorrects into this other lane and then comes through a field, strikes a fence, and down here, you can't see in this photograph exactly, but there is a drainage sewer pipe that actually winds up stopping the vehicle. So the vehicle finally comes to rest at this sewer point, which I can't illustrate on right now, but
that?
Yes.
Okay.
Unfortunately, the collision wound up killing our client's son, Ryan, but Ben did walk away from the collision basically without a scratch. And the sad part about this is Ben was actually driving under the influence, or alleged to be driving under the influence of both drugs and alcohol. And we have the police report here, and as you'll see, there was a blood test for alcohol and a blood test for drugs. That blood test was sent to the GBI, or Georgia Bureau of Investigation, which did ultimately show that Ben was driving at over double the legal limit, and then he also did have THC, or marijuana, in his system. So Ben was charged with vehicular homicide, reckless driving, and DUI, and those charges are still pending against Ben for the collision that resulted in Ryan's death.
So in a case like this, our job is to see, what can be done. Obviously, nothing can undo the loss of life, but we try to see what's out there to recover in terms of a civil case. So Brittany and I evaluated several things. Just to keep this brief, I won't go into detail, but we looked at the possibility of what's called a dram shop action, that is suing bars or restaurants where Ben had consumed alcohol. That didn't fit here. We couldn't make out a case under the dram shop statute. We considered a case about the fence placement. It was pretty close to the road. Brittany did a great job finding that out, but it turned out that given the speed at which the at-fault driver, Ben, was driving, it just wouldn't have mattered. And so we ended up looking at a sort of regular insurance case. We will typically look for 3 types of insurance and normally only find 1 or 2 in most cases. So we'll look for liability insurance. That's what the at-fault driver carries, and you're required in Georgia to have at least $25,000 of liability coverage. Then we'll look for UM, or underinsured motorist coverage, and that's coverage that people have for themselves. So our decedent, I keep calling him our client, but the decedent, our client's son, had some coverage that could cover him. A third type of coverage that we look for is called umbrella coverage, and that is rare. You do find it, but not often. And that's sort of liability coverage that an at-fault driver can have over and above the liability limits, which have to be at least $25,000. So we started looking around here, and what do we find?
So at first, our clients were told by the insurance companies before they even hired us that there was only $25,000 of liability coverage. Well, then that story changed, and they were told there was $100,000 of liability coverage. Then our clients hired us, and based on our investigation, we had a very strong suspicion that there was going to be a lot more insurance coverage, just given the financial landscape of the at-fault driver's parents and where he lived. He was a young 21-year-old, and he had still lived with his parents in a nice part of town. So we wound up having to file suit because these insurance companies would not provide us the information that we needed under a Georgia law that allows us to demand insurance coverage. Specifically, one insurance company kept ignoring us until we filed suit. So after we filed suit and obtained the documents,
We can call them by name. It was Travelers.
It was Travelers Insurance. Travelers Insurance ignored our letters demanding that they provide us the insurance information for Ben and Ben's family. They ignored those letters. We filed suit, threatened to take a deposition of a corporate representative, and eventually they provided those documents to us. And shortly thereafter, we received a letter saying that the umbrella coverage that Travelers had, which was $1 million, did not apply to our client's claim. They claimed that Ben was not an insured driver, and therefore the $1 million didn't apply. Well, we read the policy, we did research, and determined that Travelers was just wrong, and they were not being honest with us, and that $1 million policy absolutely did apply to this case and to our client's claims. And so we wound up making a demand.
Yep, I will say I'm proud of that. It's kind of sad, actually. There's a lot of plaintiffs' lawyers who won't do all that, who may not even look for the policy. If they find that the Travelers umbrella policy may exist, won't file the case. If they do file the case, won't push in discovery for it. And if they don't get it, won't notice the deposition. So it's several steps that they're not complicated, but they just take a little bit of work. And I'm sad to say that there are a lot of advertising plaintiffs' lawyers out there who don't do those things. But thankfully, Brittany did, and our firm did. So we sent a demand to the 3 insurers collectively, which is a little bit unusual, but it worked here, and we thought best for this particular case. And they all said yes. Even Travelers, after hiding the policy, after claiming their policy didn't apply, they paid up. So we ended up settling the case for the combined limits of $1,700,000. And while that's a good sum, our clients would certainly rather have their son back than have the money. But we're at least glad that we could do what we could do on the legal end of things to bring things to a successful conclusion.